Okay, we are on week 7 of your Social Security, Workers' Comp, and Bankruptcy class. We are continuing with bankruptcy. We're going to be wrapping this up in the next few weeks so that we can get into our other topics that we're going to talk about in this class. So we've gone through how you establish credit, different kinds of credit, what happens if you default on someone who gives you credit, secured and unsecured, the judicial process, how you execute on liens, and then when all else fails, filing for bankruptcy. We've gone through the different kinds of bankruptcies that are permitted under the code. We're focusing on a Chapter 7 bankruptcy, which means Chapter 7 of the U.S. Bankruptcy Code provides for total liquidation of all of your debts, which means you get a clean slate. We've talked about the various parts of the Chapter 7 petition for bankruptcy and how you file it, right? The fact that you need to make sure that you designate how you're going to pay the filing fee. You have to make sure that you have categorized all your different kinds of debts properly in all of the different schedules that are within the bankruptcy petition. You have to make sure that you, as the debtor, have signed appropriately and that the attorney or bankruptcy preparer who has helped you prepare this petition signs appropriately. Okay? We have to include a matrix, which is an alphabetical listing with addresses of all of the creditors that are listed within your schedule. So the bankruptcy court can send out notices. Hey, this particular debtor has filed for bankruptcy. You have an obligation now to protect your interests. Okay? So now we're all filed. We have a Chapter 7 petition that has been appropriately filed with the court. Let's assume the filing fee has been paid. We're moving forward. What happens when you file for a Chapter 7 bankruptcy relief within the court? What happens next? The first thing that happens is a U.S. trustee will be assigned to your case. Remember, we've gone through what is a U.S. trustee. The bankruptcy court works in conjunction with U.S. trustees that are appointed by the bankruptcy judge, and the U.S. trustee will protect the interests of a creditor throughout the process of a bankruptcy and will shepherd the debtor through the process. So, does that mean a judge doesn't really see your case? Yeah, really, it means that. For most Chapter 7 bankruptcies, you'll never see a judge if you're the debtor. The judge will never even see. What will happen is the case comes into the clerk's office. The clerk's office files it, notifies the bankruptcy trustee, and assigns it to the bankruptcy trustee. That bankruptcy trustee will then make sure that procedurally, administratively, this case goes through the process. If there's something that gets filed, if there's some kind of adversarial proceeding, then the judge might get involved. But more often than not, for a Chapter 7, no judge. So the trustee gets assigned. Now, your book goes through the duties of the bankruptcy trustee. The first thing is that they will inventory everything that is in your schedules. So if you say, hey, I own a house, or I own a house that I owe a really big mortgage on, because that's why you would be in a Chapter 7. The bankruptcy trustee has an inventory that goes into the inventory. If it says that you have, if your schedules say I own personal property, all of the different kinds of personal property and the value you have put on all of that personal property goes into an inventory that the bankruptcy trustee puts together. Why do they do that? Well, they have to make sure that if there is property that can be liquidated, to pay some of the creditors that you have, that they know, that the bankruptcy trustee knows, hey, there's a gun collection here. We're going to sell it. And then we're going to take the proceeds of that to pay some of these creditors. Okay? But what they do is they basically consolidate everything that's in your schedules onto an inventory sheet. Okay? How does a bankruptcy trustee get paid? They're entitled to reasonable compensation under the bankruptcy code. It comes from filing fees. If there are assets that have to be liquidated, some of the value, some of the money that is generated from liquidating those assets will go to the trustee. Okay? It's considered an administrative expense, and it actually goes under non-priority. It's a debt that the debtor owes to the trustee. Okay? Now, the bankruptcy trustee can hire individuals to help with the administration of the estate. Well, what kind of people would that be? Well, let's say there's real property, and we're not really sure what the value of the real property is. The trustee can hire an appraiser to go out and appraise the property. The same thing with, antiques collections, or, anything of value, a boat. Let's appraise it. Let's see what the value of this thing is. I had a case once, a bankruptcy case once, where a debtor filed for Chapter 7 bankruptcy, and he listed as some of his personal property this old boat. And it didn't run, it had holes in it, it was in a shed. Of course, this was part of a divorce also, right? And I represented the wife, and the wife was like, forget it, I don't want anything to do with this boat that he was supposed to refurbish and whatever. Well, the bankruptcy trustee kind of got a little inkling that this boat might be worth something, that it wasn't really worth like $50, and sent an appraiser out, and this thing was worth like $50,000, even in the condition it was in, because it was a rare boat. And they ended up selling it and paying their creditors. So it's the bankruptcy trustee's job to use professionals to gather information where the trustee doesn't have any expertise. I mean, I don't know about you, but I go see an old boat in a garage and I'm like, go junk it. And the trustee was savvy enough to think, I'm just going to look up the make and model of this boat, and then sent an appraiser out, and it was really worth something. Okay? Most Chapter 7 cases are no asset cases. There are very, very few cases out there where there's a $50,000 boat sitting in a garage. Most of them, people don't own real property, own the stuff that's in their apartment, own a car but have a car payment, and so the exemption covers the car payment, or they're going to reaffirm that debt so that they can have a car. And there's either a ton of medical bills or a ton of credit card debt. Those are your typical no asset cases. And in those kind of cases, obviously, we're not going to have to hire professionals to go and appraise anything, and the inventory is going to be very short. And in those kind of cases, the bankruptcy trustee, in and out. That's the job. We don't really want everybody hanging on this. Okay? What happens too when you first file your bankruptcy petition, right? The bankruptcy trustee gets appointed. Also, that matrix that we put together that lists all of the creditors in alphabetical order, the clerk, of course, is going to use that matrix to notify every creditor that's listed in your petition for bankruptcy. Hey, there's been a petition for bankruptcy filed. And then all of those creditors know, if they're secured, they can go to the court and say, I'm going to ask for my stuff back. Or if they're unsecured, they're probably out of luck. Okay? Sometimes the notice to creditors is called notice of commencement. It's the same thing. It's basically, look, you need to know that this happened. Now, attached to the notice of creditors is something called a notice of claim that the creditor needs to file with the court to protect their interest. Again, sometimes there are mistakes in bankruptcy petitions. Maybe the dollar amount is different than what the creditor has. Maybe you put down that you owe a medical bill to Dr. Smith for $50, and Dr. Smith looks at it and goes, "What, are you kidding? They owe us $5,000. And so the creditors need to file, it's called a proof of claim, not notice of claim, I'm sorry, a proof of claim with the court saying that creditor owes us this amount of money. That helps the trustee, because if the trustee is looking at the petition, is looking at the inventory, if it's not a no asset case, is going to start figuring out, okay, how are we going to get all this paid? It helps the trustee know where everybody stands. Okay, it gives them the lay of the land. The creditors will also be given, along with the debtor, what's called a notice of the first meeting of the creditors. Commonly in bankruptcy court, we call this a 341 meeting. Why is it called 341? Because it's section 341 of the Bankruptcy Code. Lawyers are not creative people, trust me. So section 341 of the Bankruptcy Code says you got to have a first meeting of the creditors. These are cattle calls. This is where the debtor comes in, meets with the bankruptcy trustee, and creditors are also allowed to come and ask questions. So, are these formal? No. It is literally a folding table with the bankruptcy trustee on one side, the debtor on the other side. Maybe some creditors will show up. 9 times out of 10, they don't show up. What happens is the trustee has a list of questions that the lawyer for the debtor will have provided ahead of time. There will be some kind of a recording device, a digital recorder. I talked to someone recently who went to a bankruptcy 341 meeting in Southern Ohio, and there was an old-fashioned tape recorder, no lie, at the hearing. The bankruptcy trustee will swear in the debtor, and they will sit down, and they will be told that everything's being recorded. They will have to give a copy of their driver's license or state ID to prove that they are who they are. And the bankruptcy trustee will go through this list of questions. So what are the list of questions? All right, what real estate do you own? What's the mortgage? Where's your tax returns? Please give me your tax returns. Are you going to get a tax refund? Where is your vehicle? Did you make any payment to creditors in one creditor in favor of another one in the 6 months prior to you filing for bankruptcy? Which is a big no-no. You don't do that. There's a list of questions that the trustee will ask the debtor. The lawyer for the debtor is also there. It's not like the debtor's just sitting there by themselves. Okay? When the trustee is finished with their list of questions, if there are any creditors there, the creditors are allowed to ask questions like, if I'm a secured creditor, where's my stuff? Where's my stuff? That's what they usually ask. Okay? After that meeting of creditors, basically the debtor doesn't have any more contact with the court. You're pretty much done. One other thing that happens at these 341 meetings is creditors will show up, or representatives of creditors will show up, and they will try and get the debtor to reaffirm their debt. So, in the old days, Sears was the big one. Sears and JCPenney, all of these creditors where they're not MasterCard, not Visa, not the big card carriers, but all the smaller card carriers, Firestone, they would show up and they would say, we would love for your debtor to reaffirm this debt. We'll get rid of all the interest that is owed. We'll make sure that they don't have to make a payment for the next 6 months or in 3 months. We'll reduce the dollar amount. they will try to entice the debtor to reaffirm the debt or continue a debt. It won't look the same as what they came into the bankruptcy with, but to reaffirm a debt. Why do they do that? Typically, these are unsecured creditors. Typically, these are creditors who know we're not going to get anything. So half a bite of the apple is better than no bite of the apple. So what they'll do is they will entice the debtor to reaffirm at least part of the debt so that they get something. They don't go up to the debtor. They can't go directly to the debtor. The debtor's represented by counsel. So the lawyers for the debtor will be swarmed by these representatives of creditors. And so the lawyer needs to know ahead of time, hey, what does your client want to do? Is there a deal that's good enough that they would want to reaffirm the debt? Is it in their best interest? You have to know all that before you go to the 341 meeting because you're going to be swarmed. Prior to the 341 meeting, a lot of representatives from creditors will call counsel for the debtor. And sometimes the debtor will say, look, I need my car. Can we please reaffirm the debt for my car? And so the lawyer will try and negotiate a good deal with the representative for the car company. It's a little harder because it's a secured debt, and the car company's like, we'll take the debt. We don't care. We'll take the car back. We don't care. So you're not in as strong a negotiating position as you are with an unsecured creditor. But, every now and then you can cut a deal. And then that representative will either show up at the 341 meeting or will simply send the paperwork to the attorney for the debtor so that can all be executed. Okay? Why do I say that they can't talk to the debtor face-to-face? Well, once you're represented by an attorney, creditors can't talk to the debtor anymore. That's the case with any kind of lawsuit. Once you're represented by an attorney, that attorney stands in your place. It's a wall between you and your creditors, or if you're in another lawsuit, it's a wall between you and the other litigants, or the attorneys for the other litigants can't call you directly. That's a wall that's there. Okay? So creditors now have to call you directly. It's one of the nice things of the notice going out by the clerk's office immediately to everybody on the matrix. They stop bugging everybody. The other thing that goes into effect right away when you file your bankruptcy is something called an automatic stay. The best way I can describe this is like when you tell your dog, stay, don't move. That's what happens to your debt. Your debt doesn't move. It doesn't accrue any more interest. No one can garnish your wages. Nobody can execute on a lien. Nobody can execute on a judgment. We're done. We are frozen. An automatic stay means everything else stops until the bankruptcy court decides what's going to happen with debtors and creditors. Okay? This is even the case with lawsuits. If I'm in the middle of a lawsuit, say a foreclosure lawsuit, that foreclosure lawsuit stops until we figure everything out in bankruptcy court. Part of the reason why this is we can't get a handle on what the debt is if the debt is always moving forward, right? If interest is continuing to accrue. We can't get a handle on the debt if there's a lawsuit going on over here that affects assets that the trustee wants to have in the inventory. We can't figure out what's going on with your assets and your liabilities if you're in the middle of a divorce and you're splitting everything up. The other part of this is, that's the practical side. The other part of this is, bankruptcy is a federal case. It's in federal court. Bankruptcy court is a federal action. Federal court supersedes everything that's going on in state court. They win. So when federal court says stop, state courts, municipal courts, you have to stop. So an automatic stay means done. No more debt collecting, no more lawsuits, no more phone calls. It's actually a really nice part of filing for a bankruptcy. And lots of people will do this. If you're in the middle of a foreclosure and they're about to send your property to sheriff's sale, automatic stay. Everything stops. Okay? It becomes a pain in the tushy if you're in the middle of a divorce and you're trying to get this thing done. The divorce has to wait until the bankruptcy is over, which is another 6 months minimum. So we have these things called a motion to lift the automatic stay. What is that? That's when you go to the court as a creditor and say, look, I am trying to evict someone who's in my apartment. They don't want to stay there. They're living there rent-free for another 6 months. That's not fair to me as a creditor. Remember, bankruptcy is there to protect the interest of creditors. And the bankruptcy court will say, yeah, that doesn't seem equitable. You're right, creditor. We're going to lift the automatic stay just for you so you can proceed with your eviction proceedings. Okay? There are also some domestic actions that the court will lift the automatic stay for. If we're trying to establish paternity, which is necessary so child support can get paid, bankruptcy court doesn't want to interfere with that. If we're trying to modify child support or modify spousal support, bankruptcy court doesn't care about that. So, because that's a debt that has to be paid. So, we don't care. We'll lift the automatic stay for that. If there is a child custody or visitation action, well, that doesn't have anything to do with anything in our inventory, so we'll lift the automatic stay for that. If there is a dissolution, not a divorce, a dissolution where everybody involved in the dissolution is involved in the bankruptcy, they'll usually lift the automatic stay. If there's a domestic violence case, bankruptcy court definitely will lift the automatic stay. If there is a tax refund that is being garnished for the purpose of paying arrearages in child support or spousal support obligations, they will lift the automatic stay. Or if there is an action out there where the Child Support Enforcement Agency is trying to hold the license of someone who hasn't paid their child support, bankruptcy court will absolutely do that. And if there is an action to report non-payment of spousal support, child support to credit reporting agency, they will lift the automatic stay. They are very liberal in lifting the automatic stay when it comes to child support, spousal support, because if you remember, those are priority debts that have to be paid. They're like taxes. And so if we can facilitate, if we as the bankruptcy court can facilitate payment of those debts, then we're going to do that. Okay? If there's an automatic stay in place that hasn't been lifted, and a creditor knows there's a bankruptcy and proceeds with a garnishment anyway, they can be punished by the bankruptcy court. There are lots and lots of tools in the toolbox for the bankruptcy court. All the debtor has to do is make the trustee aware that the creditor is knowingly violating the automatic stay, and the court goes into action. You must prove, however, that they actually knew, that they received the notice sent by the clerk's office and did something in a significant time period afterwards to violate the automatic stay. Okay? Creditors have several defenses. Their defenses usually are negated by the fact that they received the notice from the clerk's office. Okay? If you are in default to a secured creditor, the trustee and the court will usually lift the automatic stay if the debtor says, look, I don't want the car. Let him take the car. Let him proceed with that. Let's figure out how much I owe for the towing, for the attorney, for the selling of the car. And that all gets rolled right into the bankruptcy. So all of that debt goes away. It cleans the slate. And so where a secured creditor says, look, they're so far in arrears, there's no way they can reaffirm this debt. We just want our car back. Then the court will lift the automatic stay, let that process continue so that we can get all of those attorney's fees, all those extra fees that are included with the car and collecting the car rolled into the bankruptcy, and it's done. Okay? Secured property is really the only way that the court will look at a debt and then lift the automatic stay upon motion of the creditor. And again, that is mostly so that we can get everything into the package so that we can be off to the races when the case is over with. Utility services create kind of a problem. If I haven't been paying my gas bill, that could be a huge deal. The bankruptcy court prohibits utility companies from discontinuing service while the bankruptcy court is considering everything. The automatic stay goes in there. However, the utility company can require that the debtor pay what's called an adequate assurance or deposit, so that when all this old debt is gone, they can start fresh, but there has to be a deposit because the utility company has been burned once. It can't be an overburdensome deposit. It has to be within parameters. Trustee has to approve it. So it's got to be reasonable. And lots of times the court will get involved, especially if you've got like a business that is filing for Chapter 7, not an individual, and it's a substantial bill that is being wiped off because of the Chapter 7. You're going to have to put a pretty substantial deposit down, and there's probably going to be a disagreement about whether or not that's reasonable. Okay? So those are the big things that happen at the front end of a Chapter 7 bankruptcy. The automatic stay, the appointment of the trustee, some disputes about lifting the automatic stay, and the 341 meeting of creditors happens, where we're trying to see what you're reaffirming, what you're not reaffirming. Okay? Then whatever the trustee gathers from the 341 meeting is going to determine what happens later. If there are no assets, the case is probably going to be on a fast track to be discharged. If there are appraisals that are going to have to be done, if there are going to be disputes over amounts that are owed, all that information is gathered at the 341 meeting. And then in our next lecture, we're going to go through what the trustee does from that point and then how the case gets discharged. Okay? If you have any questions, don't hesitate. Contact me, email me, text me, and we'll move forward. Thank you.